welcome to 5-Minute Family Law. Today's episode, we're talking about the nuts and bolts of divorce. We'll get into the details in future episodes, but today it's just a high-level overview. So, a divorce is the legal end of the relationship between married spouses. If you're not married, no matter how long you've lived together, whether it's 2 months or 20 years, you don't need to get divorced. This is only for married spouses. Now, in order to get divorced, you need an order of the court. And what that means is that you have to start a lawsuit against your ex in the Supreme Court of British Columbia, just as if you were suing somebody that hit you with their car, or suing an employer who fired you unfairly, or if you needed to collect spousal support or divide property with your ex and they won't agree. However, before you can file the paperwork that starts your lawsuit for the divorce order, you or your spouse have to have lived in the province where you're asking for the divorce for at least 1 year before you start that lawsuit. So, if you've just moved to British Columbia and you haven't lived here for a full year, you may be able to ask for the divorce in the province where your spouse lives, as long as your spouse has lived there for a full year. Under the Divorce Act, there is only one reason why the court can make an order for your divorce. It believes that your marriage has broken down. There are, however, 3 ways you can prove that your marriage has broken down. Firstly, that you and your spouse have lived separate and apart for at least 1 year. Secondly, that your spouse committed adultery. Thirdly, that your spouse has treated you with such mental or physical cruelty that you can no longer continue to live together. Of course, none of these things are quite as simple as they sound. For example, with respect to separation, living separate and apart doesn't mean necessarily that you've moved out. You can be living separate and apart and still be under the same roof, as long as one of you has told the other that the relationship is over, and secondly, that after that point you behaved as if your relationship was over. For example, you stopped having sex together, you stopped sleeping together, you stopped doing chores for each other, you stopped going out together as a couple. All of those are the factors that indicate to the court that in fact your marriage has broken down and that you have in fact been living separate and apart. Now, with respect to adultery and cruelty, the only advantage that those grounds of marriage breakdown offer is that you don't have to wait the full year the way you have to wait a year to prove marriage breakdown on the basis of separation. On the other hand, they come with their own complications. For example, with respect to adultery, it cannot be your adultery, it has to be your spouse's adultery. And secondly, you can't prove it by your own word. You need objective evidence to establish that the adultery happened. So, for example, we're talking about a Polaroid or your ex's affidavit admitting to the adultery, but not something from which the court would have to infer that the adultery happened, like a photocopy of a receipt from a hotel, for example. The same thing kind of applies for cruelty. Firstly, it can't be your cruelty, and secondly, you need that objective evidence. So normally we're talking about an affidavit or a letter from an emergency room physician or your family doctor or a psychologist that talks about the cruelty and what happened and why it happened. And then finally, you cannot have forgiven your spouse for either the adultery or the cruelty. If the court comes to believe that you've forgiven your spouse for the adultery or the cruelty, it will assume that you have reconciled and that your marriage has not, in fact, broken down. You'll remember that in order to get divorced, you need to get a divorce order, and that to get an order, you have to start a lawsuit in the Supreme Court of British Columbia, just like you'd start any other kind of lawsuit. Well, that's complicated and it can take a lot of time. However, the court has developed a special process called the desk order divorce process that is designed to let you get your divorce without ever having to appear in front of a judge. Now, the process is complicated and it involves a lot of paperwork, and you have to do that paperwork exactly so, because if you don't do it correctly, the court will reject your application and you'll have to fix the mistakes and file your paperwork all over again. We'll talk about the desk order divorce later on in a future episode. You can, in the meantime, also go to the wiki book J.P. Boyd on Family Law, which has a complete step-by-step description of the desk order divorce process, as well as copies of the forms that you need to fill out in order to get divorced, and examples of what the forms look like when they're filled out correctly. And that is getting divorced in British Columbia.